All right. Hello, everybody, and welcome. My name is Dana Sparks. I am the broker of Maximum One Greater Atlanta Realtors and the director of the Real Estate Academy of America, which is the school offering this course for CE credit. Today's class is the 2024 GAR, Georgia Association of Realtors, contract changes, and it is I'm not covering the entire GAR purchase and sale agreement, financing exhibits, amendments. I'm not covering all of that in depth. Through our school, Real Estate Academy of America, we do have other CE classes that I invite all of you to attend. Our focus in January is on this class, the changes. But beginning in February and throughout the year, we are going to have another class called the 2025 GAR Contract Dissection, which goes through the purchase and sale agreement, the financing contingency exhibits, and the main exhibits and amendments that you use on a regular basis for residential resales. We have another class called the 2025 GAR, excuse me, Brokerage and Customer Agreements, where we go through those agreements. So we cover all of these in depth. But today is just about the changes. So I'm going to share my screen and we will dive in. So welcome everybody. And I do have the chat open so I can see all the questions in the chat. And here we go. So this is 2025 GAR contract changes, GREC course 78043. I'm the instructor. Again, my name and contact information and the school. The Real Estate Academy of America is GREC School 6915. We have to renew the end of next year. And this is a virtual remote broadcast of an approved in-class class. 3 hours of CE credit, no prerequisites, no homework. I am your instructor. The way we do attendance through this class is via the chat function. If I'm going to ask you in the chat function a couple of things. The first thing will be to enter in your name, your Georgia license number, your email address, and your phone number 3 times. Once at the beginning of class, once when we come back from break, and then one time before you leave. If you've already done so, you don't need to do so again. But if you have not already done so, please do that. There are handouts available. You don't need them for the class, but you can download them. I will go ahead and attach them in the chat, but you can also get them. I'm squinting. I'm on a different computer, so I'm squinting to see where. There we go. You can also get them if, there we go. If you go to the school's website, Real Estate Academy of America.com, I'm going to put it in the chat after everybody signs in. And then you go to video handouts, course handouts and videos, and you can download all of the handouts there as well. The other thing that we do for attendance is throughout the class, I will ask questions. And I will ask some rhetorical questions, but I will also ask questions that require you to answer. You will answer in the chat. We have a lot of people on this class, so in the interest of time, even if I have given the answer, go ahead and type in your answer anyway. That way we could demonstrate that you were actually on the class and paying attention, and you didn't just turn on your computer and walk away for 3 hours and come back. But why would you? All right, no recruiting. If anybody does, or if you have any questions, contact GREC, myself, or Heidi Kelly, who is the coordinator of our school, and she does record the CE credits. And there's her contact information at the bottom of this slide. All right, we are just going to dive in. So, generally speaking, Georgia Association of Realtors does have a licensing agreement to use their forms. If you are a realtor, meaning if you paid dues to a local board, part of your dues money goes to the state, which is the Georgia Association of Realtors, and part of your dues money goes to the national level, which is the National Association of Realtors. Therefore, if you are a realtor, that term is copyrighted by NAR. So you must belong to a board to use that term associated with your practice in your profession. Um, uh, there's no additional fee. If you are not a realtor, you have access to the GAR forms by paying GAR directly an annual fee. This year they're charging $349. One of the other parts of their licensing agreement is once the 2025 forms are released, it is a licensing violation to use any forms dated previous to the new release. Now, what does that mean? That means if you already have a listing agreement signed or property under contract or an amendment to a property, you do not have to go back and redo any of that on the new forms. What that means is from this point forward, if you initiate a new form, it must be on the 2025 forms. So some agents will have old forms stored in their computer. You cannot use those older forms. I talked about this should be 2025, about how you can access them. Um, and then you, with your NRDS number, which you get as a realtor, or if you purchase the forms directly from GAR, you get an FPID number. That stands for Forms Purchase ID Number. And you put that into FMLS. I'm more familiar with FMLS. There are other systems where agents get contracts, transaction desk through Georgia MLS, dot loop, so forth and so on. But typically, you will have to input your identification number for 2025 to access the forms. I know specifically through Georgia MLS. Other alternatives to using them, if you are a co-op agent in a transaction, the co-op agent can share forms with you. If your signature is on the signature page, if your broker has access to the GAR forms, they cannot just give you blank forms. They can sign a form. If the broker's name is pre-printed on the bottom of the GAR form, it must be the broker's signature on the form. Any additional questions? There is GAR's website and NAR's website. If you are a realtor, additionally, one of the services through the Georgia Association of Realtors is there is a legal helpline, but you must be a realtor. Um, uh, uh, because you have to input your NRDS number. And there are, I have on this slide, ways to find your NRDS number. It's not easy to find, but you can find it. Okay, a question. Seller's property disclosure form and the community association disclosure. House listed, not under contract. Should they be rewritten on a 2025 form? I will let you know that, especially with all the weather we've been having in Georgia with the rain and the snow and the ice and everything, it might not be a bad idea to make sure that your sellers, their property disclosure forms, are current and updated. If they've had any issues since the house has been listed or they have first filled out those forms, it's required that they update those forms anyway. So if there is a need to update a seller's property disclosure form, I highly suggest you update it on the 2025 form. I will let you know that for 2025, there were no changes to the community association disclosure. So there's no need to have your sellers refill that on a 2025 form. Again, unless the HOA from the time they filled it out has changed anything. And in the seller's property disclosure form, you'll see they've just added 2 more questions. So I would suggest only if anything has been updated from when your sellers first filled those out. All right. Again, today we are going to talk about the changes. We're not going through everything. Everybody always has questions, but this class is really just to highlight the changes. And GAR does a really nice thing. They always print what the changes are, which is very, very helpful. So wherever it is that you go to access your forms, wherever it is you go to access your purchase and sale agreements, your exhibits, your amendments, there is a document there you can review for yourself that has the changes, as well as table of contents and an index. Remember that GAR also makes mid-year changes around the spring every year. And today's class, typically a lot of y'all don't take a contracts class except for January, February every year. So today's class, I will cover the changes that GAR made last year, July 1st, 2024. Now, a lot of those changes they made have already been changed for January. So if something has already been revised, I won't cover it. But if something was changed in July 1st of 2024, and has remained the same, I will address it in this class as well. But this is the forms that I'm talking about. Again, wherever it is that you access your forms, you can pull up this document that does show every single change that GAR made to the forms. Now, a lot of these have to do with renumbering of paragraphs or grammar corrections, syntax corrections, but it also shows very substantial changes. And today, again, there are lots and lots of changes they made for 2025. We're not covering all of them, just the major ones. So, as an overview, 3 forms were eliminated. 1 form was renamed, 9 new forms. You guys, I cannot remember. I have been practicing real estate in Georgia for 30 years. And it'll be, yeah, 30 years this year. And I cannot remember a time when they added 9 new forms all at once. So, woo, hold on. We are going to cover all of those forms. 1 new consumer brochure, 1 special stipulation was modified. Now, what prompts all of these changes? Well, a lot of the changes are prompted by agents practicing real estate here in Georgia. And it's like, wow, this occurs, this occurs, this occurs. Let me reach out to GAR and see if they can address this in the forms, because I, as an agent, am dealing with this was a lot of times it is a practice change. This year, the majority of changes had to do with there was a new Georgia law that was passed in 2024. So there are a lot of changes. Well, there's one change throughout many forms that reflects that. Changes in federal regulations, specifically, the EPA has modified the regulations regarding lead-based paint and lead-based paint disclosures, and of course, the NAR settlement. So the majority of changes for 2025 have to do with those 3 issues. The NAR settlement did receive final approval in November of 2024. However, it is still under appeal. And you guys, this lawsuit is going to go on for years, various lawsuits and offshoots. But nevertheless, at any one point in time, the Georgia Association of Realtors Forms Committee does what they need to do to protect us as agents, whether you're a realtor or not, any agent using their form and brokers here in Georgia. I will tell you parenthetically, from keeping up with the terms of the NAR settlement and the arguments going back and forth and some of the reactions among real estate agents throughout the country that I am seeing on some national Facebook groups, YouTube channels, things like that. Y'all, Georgia is so far ahead of many, many other states in the country with respect to these issues that the lawsuit was addressing. And For us in Georgia, as this lawsuit has been going on, and even some of the changes now, you're like, what is the big deal? It's hard sometimes for us as Georgia practitioners to understand what all the hoopla is about, because we've had to disclose compensation to our public. It's been in our contracts for years. We've had buyer agency laws since 2000. And there are a lot of state, not every state has buyer agency laws. Not every state has disclosed commission and compensation to their public, even in the brokerage and customer agreements. So things that we take for granted here that have been in our contract forms for many years, they've undergone some slight variations and changes. There's a lot of states that this is all brand new to them. So once you start to understand that, it does become a bigger deal, but not for us in Georgia. Nevertheless, GAR has uh, made some changes to the forms to reflect the current terms of the settlement. All right, so moving on, what forms were eliminated? Well, these three forms, the seller financing exhibit, one with dealing with a third mortgage, the other with a wraparound mortgage, and the subordination agreement, those have been eliminated. GAR stated that these forms have rarely been used in years, so they just did away with them. Oops. The form that was renamed, and I see a lot of friends on here, a lot of friendly faces, and a lot of newcomers. So welcome. I do welcome you if this is your first time taking a class with me or taking a class through the Real Estate Academy of America. I welcome you, and I hope you will take more. Um, I like to teach in such a way that things make sense to you, and that the 3 hours goes by fast, and the CE credit is bonus. So at the end of the class, I hope that I achieve my goal, and I hope that I properly reflect um, honor and glory to God, who has given me this opportunity to share all of this information with you guys. But if you've been on any of my classes or in any of my sales meetings or anything, have seen any of my videos. I also have a YouTube channel called Real Estate Made Crystal Clear, geared towards agents throughout all of Georgia, and I cover a lot of forms in depth. Like, we're going to breeze through a lot of this stuff, and I cover this in 15 to 20-minute videos. But the broker compensation exhibit F-259 that came out in July of 2024 has been aptly changed. Buyers brokers compensation. We knew this was coming, and I'll explain more when we get to that form. The special stipulation that was modified is the amendment to address concerns as notice to terminate. I'll cover that towards the end of class. 9 new forms, 1 new brochure. These are the new forms. We're going to cover them all, but I just wanted to give you a list. Sellers, brokers, notice to unrepresented buyer. Showing agreement. Buyers, brokers, notice to seller of seller's obligations regarding lead-based paint. That one's based on the EPA updated EPA federal regulations. Sellers, brokers, notice to seller of seller's obligations regarding lead-based paint. Visitor sign-in sheet and disclaimer, that's for resale property. Viewing a house under construction, that's the exact same form, but that's for new construction. The next 3 forms have to do with leases. Application for reasonable accommodation or modification. Policy to allow reasonable accommodation and modification for persons with disabilities, exhibit. And the response to the request for reasonable accommodation or modification. And then the new consumer brochure that has to do with a new law that Georgia passed in 2024. And that is called CB 29. What buyers, sellers, and realtors need to know about buying agricultural land and land near military bases, installations, and airports. All right. Now, what are just GAR always makes some universal changes throughout. Um, a universal change would be throughout every document where it addresses this issue, they've changed it. So, what are some of those universal changes? Well, commission is now compensation or compensation for professional services. That's in direct response to the terms of the NAR settlement. There is a paragraph throughout the brokerage agreements and the purchase and sale agreements that talks about the GAR forms. It's a pretty extensive paragraph that goes on and on that states that no one is required to use the GAR forms. The public should seek legal advice if they're concerned about a contract meeting their needs. The forms must be used in agreement with the GAR licensing agreement. And regardless of what the parties intend, a judge or an arbitrator has 100% authority to make their own interpretation. So the forms would be used for attorneys to argue a person's position, but a judge can have a different take. So all of that is still in there, but they just changed a little bit universally for 2025, where they removed the sentence that says they may need to be modified to meet the specific needs, and changed that to the parties agree, meaning the buyers and the public people agree to carefully review the GAR forms to be used and modify the same to meet their specific needs. Another universal change is the statute of limitations under which a person can bring a claim against you has changed. It used to be 2 years; they shortened it to 1 year. And then another universal change is above all the signature lines. This is great. This is a good reminder to our public as well as to our agents that if a buyer or seller is a legal entity, this agreement must be signed by one or more authorized persons as required in the entity's legal documents. The person's signature must include the capacity in which the person is signing, such as trustee, general partner, manager, president, member, etc. So if your client or customer is an LLC, is a trust, is an executor, then this is just a reminder that they need to sign it reflecting that it is an entity that is the buyer, seller, landlord, or tenant. And this uh, reminder is above every signature line. All right, here we go. We're going to dive into the actual specific changes for 2025. Now, I'm going to back up a little bit and I'm going to speak generally about money. Let's talk about money and what agents do to get paid for the work they do in real estate. A lot of the changes, the majority of the substantial changes, do have to do with compensation. So, there is an article. Never take what any instructor says at face value. You always want what's the source? Why am I saying that? Me, any instructor you take a class from. Why are you saying that? Well, so this information is from an article by Seth Weissman. Seth Weissman is lead counsel for the Georgia Association of Realtors with Weissman Law. He is also the biggest closing attorney in Georgia. And this is from an article that he wrote in the Georgia Realtor magazine that was published in 2024. And generally speaking, with respect to the GAR contracts, GAR will continue to amend its forms as NAR offers further guidance on how to comply with the settlement. GAR has identified changes that will be reflected in the 2025 forms package and practice changes that are now required. Most impact buyer broker compensation. I'm going to come back to this when we get to those specific paragraphs that have been changed. Now, let's think about how you get paid. How do you get paid for the work you do as a real estate agent? Well, how does a seller's broker get paid? Well, let me back up. throughout this course, I'm going to use the term broker. Why? Because that's who gets paid. All commission, all compensation with respect to a contract belongs to a broker. You as an agent, you get paid by virtue of what you agreed upon with your broker in your independent contractor agreement. But all the contracts, the brokerage agreements, the customer agreements, purchase and sale agreements, whenever they address compensation commission to a broker, it is to a broker. So how does it now? Your broker has to get paid so that we can pay you, our agent, our affiliated licensee. You're affiliated with your broker. So this does impact you, but it is correct to speak about it in terms of broker compensation. So, how many ways can a seller's broker get paid? A seller's broker can get paid one way, directly from the seller. The amount that a seller's broker gets paid is negotiated and agreed to in a seller brokerage agreement if you're working with that public seller as a client, or in an authorization to show unlisted property if you are working with that seller as a customer. Now, so a seller's broker gets paid one way. What about a buyer's broker? Buyer's brokers, y'all, buyer's brokers get paid three ways or in a combination of the three. Either directly from the buyer, directly from the seller, or from the seller's broker, which is what we have for years and years and years referred to as a co-op transaction. It is a cooperative payment between brokers. So basically, what a co-op means is the seller has agreed to pay their broker a big pile of money. Their broker has agreed to share part of that pile of money with a broker representing a buyer. So that is the co-op financial arrangement. That's what we refer to as a co-op. Seller paid their broker is sharing. So that is still in effect. Or the seller can say, I'm going to cut out the middleman, so to speak, and I'm going to agree to pay the buyer's broker directly. So I'm going to agree to pay my broker a certain amount, and I'm going to agree to pay a buyer's broker a certain amount, but that's going to be negotiated in the contract rather than the seller giving their broker a big pile of money to share, or a buyer can pay their broker directly, or any combination thereof. So there are a lot of new forms and a special stipulation that address buyers brokers compensation, and a lot of the changes have to do with that because there's so many ways now that a buyer's, well, it's always been, but highlighted now since all of the NAR and lawsuits that have been in the news for the past year and more. So that's just generally compensation. So now let me go specifically. Let's talk about the seller's brokers exhibit, the exclusive seller brokerage agreement. So let me show you. I'm going to do a couple things. Let me show you this is the actual. I'm going to go back to the slides because I have it more specifically in the slides. But I think sometimes it's a little bit easier to see in context. So this is the 2025 version of the exclusive seller brokerage agreement. And so you'll see, I'm going to go back to the slides where I can talk about it more specifically. These are part of the handouts that are available to you. Oh, I told you guys I would do that. Let me do this. In the chat, I'm going to do a couple things. I am going to attach a PDF of the entire handout that has the slides, PDF version of the slides, and all of these versions. I'm sorry, all of these forms. You can also go to, I'm putting it in the chat, so give me a second. Real estate academyofamerica.com. Go to course, handouts, and videos, and you can download all of the individual forms directly from there as well. So I have that in the chat for you. You can click on that directly from the chat. You can download the handout, and I'll cover that again after break. But what you get in your handouts will be, again, a PDF of all my slides, and you'll get these forms with the underlines. So again, just to show you in context, right now we're going to talk about the exclusive seller brokerage agreement. This is the compensation paragraph. I'm going to come back to this in just a minute. This is the protection period that got changed. The marketing paragraph got changed. Well, I'm going to go back. I'll go back and forth. All right, let's start off with the compensation section. This is paragraph A4, where the public seller and you as the agent working for your buyer, working for your broker, negotiate compensation. How much is a public seller going to pay you for the professional services of helping them list their home, negotiate the contract, and get it sold? So now let me go back to the slides and go through what the actual 2025 changes are. So the first section states that compensation to the broker is negotiable and not set by law. Now, in January, GAR, we love GAR, Georgia Association of Realtors, is definitely looking out for agents and brokers. In July, they changed this, and the paragraph A4A had that sentence, and it had a period, and then it also said, however, this does not obligate individual licensees and brokerage firms to necessarily negotiate their compensation. Well, NAR had to approve the GAR contracts, and NAR said, you got to take out that second sentence. That goes against the terms of the NAR settlement. And GAR is also a member of NAR, so they have to adhere to those terms. So in the actual forms, they have taken that last sentence out where it says it doesn't obligate individual licensees or firms to necessarily negotiate. However, firms and licensees may still set their own fees and have policies regarding the compensation they charge. That is not from me as an instructor. That is directly from Seth Weisman from that article that I quoted that came out November 2024 in the Georgia Realtor magazine. Now, in essence, you're negotiating. I negotiated my fee is X amount. I don't have to negotiate off of that. You can ask for a different amount, but I am allowed to have a policy as a brokerage or as an affiliated licensee. If your broker allows you to negotiate your own compensation, at Maximum One, we do allow our agents are CEOs of their own businesses. We do allow them to negotiate their fees. I've been with Maximum One for many years, so I'm not sure what other brokerages are doing. When I've been in other brokerages, they did not allow you to. So I'm not sure. You need to check with your broker regarding what your broker allows you to do regarding negotiating. And your broker may have a policy regarding what they allow you to charge. But Seth says you can still have for policies and procedures, but they had to take that verbiage out of the exclusive seller brokerage agreement. So no change to the second section. The second section is where you actually, the seller does agree to how much the seller is going to pay their broker for the job of selling, of listing and getting their home to close. And that amount is expressed as a percent of the sale price, a flat fee, or any other arrangement. Now, section A4C did get changed. So it got reworded a little bit and changed. So in this section, it states that the title of this subparagraph is whether compensation is paid to a buyer's broker or not. Seller hereby approves of the following. Select all which are applicable. 1, the seller is not initially offering compensation to a buyer's broker, but marketing that they are open to receiving offers in which the seller pays compensation. In other words, yeah, the seller said you're on a listing appointment and you have this discussion with the seller about compensation. Well, they're going to pay your broker for you representing them and getting the job done. And then your discussion goes, now there is another compensation. There's typically going to be another broker involved representing a buyer, working with a buyer. Are you going to compensate them or not? And you go through that whole discussion. The seller says, yeah, I'll definitely be willing to compensate a seller's broker, but I'm not going to let them know how much. I'm not going to put it out there how much I'm going to pay them because why? Why? Answer in the chat. Why initially, if a seller is willing to go ahead and compensate, pay a broker working with a buyer, but they don't want you to initially market or tell the buyer's broker how much. Why? What are they waiting for? Yeah. Yeah, exactly. Answer in the chat. Why wouldn't a seller want a specific amount out there initially? Exactly. It's a point of negotiation. If they put that money out there, then they're saying that's what they're going to pay. So yes, you guys, great. Y'all are all on target. So a seller's saying, I'm still willing to pay. I just don't want you to initially market how much, but you can market that I am willing to pay. Bring me an offer and put it in your offer, and we'll negotiate that as a term of the offer. Now, the second section, again, we're talking about whether or not a seller is paying compensation to a buyer's broker. Compensation is being paid to the seller's broker by either that should be buyer's broker. That needs to be reworded. That's a typo. Compensation being paid to the buyer's broker by either the seller, in addition to how much they're paying their own broker, the seller's broker out of the compensation that the seller's broker is getting paid, or both, as described in other. Okay, so this is a little bit complicated, but let me explain what this is saying. This is saying the seller is saying, yep, I totally agree to compensate a broker working with a buyer. Not only do I agree to it, here is exactly how much I am going to offer a broker. I'm going to compensate a broker working with a buyer. And that amount is expressed as a percent of the sale price, a flat fee, or another arrangement. However, so where is this money coming from? So those are these three options. The money is coming from the seller directly. So the seller is saying, I'm going to pay X percent, but that is coming from the seller directly. The second little box is coming from the seller's broker out of the compensation being paid. So the seller says, okay, broker, this second little box, you guys, that's what we refer to as a co-op compensation plan, what we've done for many, many years. The seller is going to pay their broker a big pile of money, and their broker, the seller, is directing their broker to share part of that money from the amount they're paying them with the buyer's broker. So if this and the third one is a combination or something special. So if you mark this box, the seller is going to compensate the buyer's broker directly. Then up here in B, this is the amount the seller is paying the listing broker. This is the amount the seller is paying the buyer's broker. If you mark this little box that the seller's broker is, the listing broker is to share the amount with the buyer's broker, if that's what the seller directs you to do, then this amount up here is going to be a larger amount than this amount here. If the seller is paying the buyer's broker directly, these two can be different. They can be the same, or they can be different. If you're marking this one, this is a traditional co-op, then this amount is going to be larger than this amount. If you have 10 up here and you put 10 down here, 10 minus 10 is 0, and the listing broker gets nothing. So if you're marking this little box a co-op, then this amount minus this amount would be what the listing broker gets. And then C would be some other arrangement as set out here. And this would be something we've seen this advertised in the MLS services throughout previous years, where it says buyer's broker. I'm not seeing this as much actually, because we're not initially offering. If a seller chooses to not initially offer compensation, then we're not seeing this as much. But it could be something to the effect of buyer's broker's compensation to be a certain amount if buyer's agent is not present at time of first showing. You guys are all familiar with those provisions that we have seen in the past year. So something like that would be discussed or arranged. Seller must agree to it. And in other would be, I'm sorry, that would be in this last box. If seller's offer is conditional upon something about showing, sale price of the offer, a certain close date, so forth and so on. And now we have this third option. Now, this third option can be confusing, but I'm going to try to unconfuse it for you. It says no compensation is being offered or marketed to the buyer's brokers. So that's a seller saying, you, my listing agent, are not to market that I am paying any compensation. Now, listing agents, do not violate license law. License law, GREC Rule 520-1-.101 states you must present all offers. You must present all offers if it's asking the seller for compensation for their broker or not. So you have to present all offers. It's up to a seller to agree to an offer, counter an offer, or make or reject an offer, but you have to present it. Now is the time, at the listing appointment is the time to discuss this with your sellers, because you don't want any of your public sellers jumping down your throat saying, I told you not to offer any compensation, or I'm not paying a buyer's broker. How dare you bring me this offer? Now at the listing appointment is when you say, I have to present you with all offers. We can negotiate this. This is just a term, but you need to present this now. But this has to do with marketing a seller's agreement to offer a compensation to a buyer's broker. Okay, question. Can a buyer's agent ask the seller's agent prior to showing if the seller agreed to compensate the buyer's broker? Great question, Fallon. And the short answer is yes. The long answer is yes. But how? And I will show you the other forms that a buyer's agent would do to take that into account prior to showing a house. So great segue into a little bit later on into the presentation. All right. So those are the changes to the seller's brokerage agreement. These next few slides are just putting in words what I just stated. All right, moving along. The GAR for 2025, yes, for typo. Yes, Holly. This has a typo. I need to bring this to GAR's attention. That'll probably get changed mid-year, where it says compensation being paid to, that should say buyer's broker. Oh, it has been corrected. Thank you, Todd. Okay, so it has been corrected. I got training versions of these forms back in December. Perfect. Good deal. All right. Moving along, the next change GAR made in the seller brokerage agreement is the protection period. This just makes sense. Thank you, GAR, for doing this. In 2024, It just stated the length of the protected period as that firm is defined shall be X number of days. Okay, before I go to the next slide, y'all, what's being protected? What's being protected in the protection period? Type in the chat. What's being protected? Yeah, your money. Your money is being protected. Well, it just said the protection period. Well, to our public people, what does that mean? What is protected? Am I protected? I don't know. Are you protected? Who's protected? What's protected? So GAR clarified that. I like this change. GAR clarified that in 2025. So in 2025, the protection period reads in paragraph A, where you fill in the blank and negotiate the amount of time, the length of the protected period during which broker shall be entitled to compensation under certain circumstances where this agreement has been unilaterally terminated by the seller or has expired shall be X number of days. So they just clarified what's actually being protected. And these certain circumstances, that is all spelled out in paragraph B5, the corresponding paragraph to the protection period. But that's a really nice clarifying change. Now, this is just a minor change unilaterally. Let me show you where this is in the contract because this is important. Even though it's a minor change, it's important. Okay, I hope I'm not making y'all dizzy, but I am. Okay. This is where we begin the B, paragraph B, which is all the legalese and sellers. You have negotiated with your broker, all these fill in the blanks. You've agreed to do all of this stuff. Now, what is it that you've actually agreed to? All of that is further explained in this subparagraph B. So this first paragraph says, okay, seller, when you sign this agreement with me, you are stating that you are signing an exclusive brokerage agreement with me, meaning I am the only broker with whom you have signed an agreement to work to represent you to everything I have to do to get your home sold. You are telling me you are no longer party to an agreement and that you did not unilaterally terminate a previous agreement, a previous seller brokerage agreement with another broker. Unilaterally means it didn't have signature from both you, the seller, and the broker. Unilaterally means one signature. Easy to remember. A unicycle has how many wheels? One wheel. Uh, a unicorn has how many horns? One horn. Uni is the Latin prefix for one. So whenever you see unilaterally, it means there was only one signature done. So if a seller has unilaterally terminated a previous seller brokerage agreement, then guess what? They could be responsible to that previous broker for money. And so it is the seller saying, look, you're saying that GAR's put in here, look, seller, if you unilaterally terminated a previous brokerage agreement, no, they're no longer representing you as a client, but you still possibly could owe them some compensation. So GAR just clarified that there's a difference between a mutual termination and a unilateral termination. Now, the next section, this marketing section, all of this verbiage, most of this verbiage has already been there, but it was in one big old long huge paragraph that nobody read. And so for ease of reading and understanding and for talking points, GAR has separated out these paragraphs where it is much easier to read. So they did add a couple of new paragraphs. I say new, this verbiage had already been in the GAR purchase and sale seller brokerage agreement. It had been in a different paragraph, but basically the marketing materials and liability for misinformation. Marketing materials, if the seller pays for any photographs, marketing, drone photos, so forth and so on, that material belongs to the seller, and the seller can give permission to whomever they want to use those photographs. If you, however, paid for professional photographs, drone photographs, so forth and so on, those photographs belong to you. And if for some reason you don't get the seller's home sold, the seller lists with another broker, they may not use your photographs without your written permission. So basically, who pays for the marketing materials owns the marketing materials. And this paragraph about liability for misinformation, let me make this a little bigger. This just states that you are going by the seller warrants that whatever information they give to you about the house is true to the best of their understanding, and that you, as the broker, can't get sued for misinformation because it's came from the seller. Now, me included, whenever you hear an instructor, a broker, GAR, read it in the contract where it says you cannot be sued. Take that, everybody, with a grain of salt. Anybody can sue anybody for anything. I don't care what I agreed to, I can still sue you. However, what this says, where it says they agree to uh uh hold the broker harmless from any and all claims, causes of action, suits. That says that means the seller says, I agree not to sue you. But guess what? The seller sues you anyway. So what does that mean? Well, okay, Dana, if you're telling me they can sue me, but this says they can't, what on earth are you talking about? Well, as I mentioned previously, this contract is what your attorney will use to argue in front of a judge that, hey, seller, when you sign this, you agreed to not sue me. Now, don't get me wrong, they can sue you for fraud if you've done something fraudulent. But so the contract gives your attorney the groundwork to make the legal argument to protect you in front of a judge or an arbitrator. Um, so the question, what is an example of a seller still being liable to pay the listing agent compensation after the seller unilaterally terminated? They unilaterally terminated with broker A. Let's say they listed with broker A. Broker A, there was a buyer's agent that brought a buyer. I'm sorry, the listing agent had a buyer. There was a contract and it fell out for whatever reason. The seller unilaterally terminated. Well, anyway, I'm not going to get into an example right now. I started to. We've got too much to cover. Take our GAR contract dissection class, and I'll go over that. Or contact me after class, and I'll go over that. New construction delays of time delays, that is built into your new construction contracts. Y'all need to read those new construction contracts. They have a lot of delays protections built in there. All right. Continuing on, this is again the terms of the protection period. Okay. Moving on, what about lead-based paint? Well, the EPA in April of 2024, they modified the language, they modified their regulations. So GAR in July of 2024 has modified their contract forms to reflect the updated regulations that the EPA, the federal regulations per the EPA. So basically, we know that if a house was built prior to 1978, or if there is a lead-based paint hazard in the house, meaning antique mantelpiece, reclaimed barn wood, shiplap, things like that, that possibly could have been painted prior to 1978, that per the EPA federal regulations, you must disclose this to a buyer. So the EPA just further clarified what a seller and what agents and brokers must do regarding these disclosures to potential buyers. So as required by federal law, Residential Lead-Based Paint Hazard Reduction Act of 1992, Title 10. If any portion of a residential dwelling was built prior to 78, the lead-based paint disclosure exhibit F316 is hereby attached as an exhibit to this agreement. That's been there. The term residential dwelling includes any painted fixture material used that was built or manufactured prior to 78. That's what I just said. The seller understands. So basically, what it used to say is, seller, you must perform your duties as a seller and disclose the appropriate information to a buyer. But it never said exactly what the seller was supposed to disclose. So GAR has added, the seller understands, okay, seller, here is what you must disclose to a potential buyer. Number one, disclose to the buyer the presence of known lead-based paint and/or lead-based paint hazards. Two, provide the buyer with all available records and reports pertaining to lead-based paint and lead-based paint hazards in the residential housing. Three, provide the buyer with a lead-based paint hazard information pamphlet in a form approved by the EPA. And four, permit the buyer to have a 10-day period to conduct a risk assessment or inspection for the presence of lead-based paint hazards. So GAR has just added the four things a seller must disclose and what they must do to comply with the EPA if the house or anything in the house was painted prior to 1978. So that's how it looks in the paragraph. Couple things here. Listing agents, bring a lead-based paint disclosure with you so that a seller can potentially fill it out. Because even though you look on the tax records and a house was built in 2000, until you actually see the house, you don't know if maybe they have an antique mantelpiece in there. If the seller corrected the lead-based paint, do they have to say it has lead-based paint? Great question. You should ask your broker. As an instructor, I think it's always best to disclose and let the buyer have that information so the buyer can proceed how they choose. One other thing I need to inform you guys of, this 10-day risk assessment, that is in addition to a due diligence period. It is a separate inspection just for lead-based paint. So let me go back to the slideshow and where did it go? Let me see if there's anything I have missed. All right. So we're going to go over the lead-based paint disclosure exhibit because that changed also. And this change in the EPA's federal regulation in April prompted two of the 9 new forms. And those tie into the exhibit. So give me 1 second. Okay. That's what it looked like before. Basically in 2024, it just said, seller, you have to disclose to the buyer. In 2025, they spelled out exactly what they have to disclose. Now, the lead-based paint disclosure exhibit. Let me show you what that looks like, what got changed. There are 2 of them. F316 is the lead-based paint disclosure exhibit for residential resales. 918 is the exact same, but it references a lease. Let me show you. Let's look at the form a little bit more in depth because I will show you the changes, and this gets a little confusing, but I want to unconfuse it for you. I guess that is I guess I should say clarify. Okay. This got changed in July of 2024, but there's new forms that go with this. So this is the lead-based paint exhibit. You guys are all familiar with this. The seller says if they do know or don't know of lead-based paint hazards, what records they have, buyer's acknowledgement. So that would go with an offer for the buyer to acknowledge. Buyer does or waives their right to the 10-day inspection period. Okay. Now, this is now for you as the agent. When you are helping sellers fill this out, you also have to acknowledge this. You have to acknowledge that you informed the seller of their obligations. So you listing agents, you are going to initial here. Seller's agent has informed the seller of the seller's obligations. In July, of 2024, GAR added this next section. Buyer's agent has informed the seller of their seller's obligations. What on earth? I'm a buyer's agent. What do I have to do? Why do I have to inform a seller of their obligations with respect to lead-based paint or potential lead-based paint? Okay, let's keep reading. It says this buyer's agent, you buyer's agents, you only have to initial if you, the buyer's agent, should be broker, are receiving compensation directly from the seller. So if it is a co-op deal and the buyer's broker is getting paid from the seller's broker, you do not have to initial this. If, however, it's negotiated in the purchase and sale agreement that your compensation is coming directly from the seller, house is built prior to 78, or there's a lead-based paint hazard in the house, you also need to initial this. So it says buyer's agent has informed the seller of their obligations. Okay, you initial this. That was in July. However, you now have to perform. Have you informed the seller? What is it you're supposed to inform the seller of? That is why in 2025, GAR came up with 2 new forms. This form is the buyer's broker's notice to the seller regarding their obligation of lead-based paint. Again, you, the buyer's agent, you are getting paid directly from the seller. You know that because it is negotiated in the buyer's offer. The house was built prior to 1978. Obviously, this exhibit, lead-based paint exhibit, must be included. Now, you, the buyer's agent, not only do you have to initial that you have informed the seller of their obligations, but you also have to inform the seller of their obligations. Well, how do you do that? You do that now with this notice. Buyer's broker's notice to seller of their obligations regarding lead-based paint. You identify the property, you put in the buyer's name, and these are those 4 things that we just talked about. The seller is required to disclose to the buyer presence of known lead-based paint, provide them with records, give them the information pamphlet, and allow them to have a 10-day risk assessment. Again, you only send this and sign. It's unilateral, so it only needs your signature, only if you're getting paid directly from the seller. Now you're thinking, well, gosh, okay, so I do that, but I don't want to cross a sign. I can't communicate directly with the seller. Well, if the seller is working with their listing broker as a client, then we know from the purchase and sale agreement, notice to the agent serves as notice to the client. So you buyers agents, if all of those things that I've said repeatedly are in place, you fill this out, you sign it, and you send that to the listing agent, and then you have performed your duty per the EPA and per the terms of the contract. While we're here, let me show you one other new form. I'll try again. It is, the other new form is, the other new form is called the seller's broker's notice to seller regarding of lead-based paint. Okay, my thing's going crazy, so hang on. Oh, you know what happened? Okay, it is while I'm trying to do this, give me 1 second. It is the 2025. All right, my computer is acting funky. Here we go. Here we go. It's just taking a minute to catch up. The other new form is 318. This is the seller's broker's notice. It's the exact same form. You listing agreements, you don't need this. If the seller signs the exclusive seller brokerage agreement, this is the exact same verbiage that we just went over in the seller brokerage agreement, B7. So you don't need this in addition to. So why do they have this? Well, you could be working with a seller who has not signed the seller brokerage agreement. And let's say it's a for sale by owner. They haven't signed anything. They haven't signed authorization to show unlisted property. They haven't signed anything, but the house was built prior to 78. Guess what? You still have to comply with the EPA so that you are not fined. I believe it's now $18,000 per missing initial. So GAR has created this form for you listing agents, not listing agents, you agents working with sellers, if they have not signed the seller brokerage agreement. If they have, again, that verbiage is already in there. So those are the two new forms and the new lead-based paint. It's a big deal because it is the EPA. All right. Let me look at the questions. Sellers. Okay, the sellers don't have to complete it again, Todd. This is just the agents. They don't. The agent just has to initial. So let me go back. This is the seller's brokerage agreement that the listing agent hopefully got filled out at the listing appointment. This will be included in an offer. So listing agents, you need to make this form available to potential buyers agents and potential buyers. You buyers agents, if you know the house is built prior to 78, if you don't have access to it through one of the MLS services, you need to ask the listing agent for it. And if you are constructing an offer where you're asking the seller to pay you directly, not only does your buyer need to sign it, you need to initial it. So the seller's not completing a new one. And then buyer's agent, you have to send them that notice. So I hope that made sense. The blank line, F317, the blank line, is it the agent's name or the agent's broker? Signature of buyer's broker. I would put your name actually. In the GAR contract, it does say that broker and agent can be used interchangeably. So refer to your broker, see what your broker's policy is on that. If I'm an agent, I want my name on there to show that I complied with the EPA. Your brokers might say they want their name and signature on that to show they did. So that's going to be a broker question. Good question, though. Shouldn't G say the name of the notice? Anything different? Nothing different on the lead-based paint disclosure for a lease. It's the exact same. It just references a lease rather than a sale. I'm not sure, G, what you're talking about, unless you're talking about, let's go back to the listing agreement. I'm not quite sure what you're asking for. If you're talking about this. So I'm sorry, Ian, I don't understand your question. All right. All right, so that's it with lead-based paint. And again, a pretty big deal because you don't want to get fined by the EPA. All right. Now, moving along, there are other changes that have been changed based on a new law in Georgia that went into effect July 1st of 2024. It is Georgia Code Section 2-1-7 that limits the ability of non-resident aliens to acquire land in Georgia. There is a note that this provision of this subparagraph shall not be in conflict with the Federal Fair Housing Act. The Georgia Forms in 2025 new brochure, consumer brochure CB 29, reflect this new Georgia law. The law has to do with land, not residential property. And so therefore, this new paragraph is in the brokerage agreements and it is in the land purchase and sale agreements, but it is not in the residential resale purchase and sale agreements because it only impacts land. So a broker who is engaged by a client who is a prospective buyer or seller or has possessory interest in agricultural land or land within a 10-mile radius of any military base, military installation, or military airport shall timely disclose to said client that the requirements and limitations in the Georgia code section. Y'all, don't get hung up on the words when it says client. If you are working with a prospective buyer or seller and they haven't signed a brokerage agreement, so they're not your client, they're your customer, you better still comply with this Georgia law. I can almost guarantee you a judge is going to say, if you had knowledge of the law and you had knowledge that your person with whom you're working is a resident, non-resident alien, you need to have disclosed this information to them, regardless if they were a quote unquote client or customer. So don't let that hang you up. If you don't know what a non-resident alien is, or you're not sure if the person with whom you're working falls into that category, you need to direct them to an attorney to see what that person may or may not do with respect to the Georgia law and their status as looked at by the state of Georgia. Point of practice, you also need to give them Consumer Brochure 29. And any questions, again, you guys, you are not attorneys. Your brokers are not attorneys, especially with respect to a brand new law. Get them to an attorney. So here is the disclaimer. Again, this is in the brokerage agreements and the purchase and sale for land, but not new construction and not residential, because it's only for land. So here's what it says. It's paragraph C4F, and it states, disclaimer regarding the sale of certain property. And again, this came out in our contracts in July of 2024. What's new in 2025 is the consumer brochure that I'll show you in just a second. So it states, seller acknowledges that Georgia Code 217 prohibits certain non-resident aliens, foreign persons, foreign companies, and U.S. companies owned by any of the above from buying or possessing agricultural land and certain land within a 10-mile radius of any military base, military installation, or military airport. Seller agrees to carefully read the entirety of the above referenced code section before contracting to sell such land. Seller should consult with legal counsel to fully understand the law. If seller has not submitted written questions to broker regarding the law to the broker prior to contracting to sell prohibited property, seller acknowledges that seller fully understands the limitations and requirements of the law, and the broker shall have no responsibility for further doing the same. In such event, seller shall indemnify and hold broker harmless from any and all claims, causes of action, suits, and damages arising out of or relating to seller's failure to comply with the law. Violating the law can subject the seller to civil and criminal penalties. The law also requires certain sellers and others to divest themselves of such property within certain time periods if they are now no longer legally able to purchase such property. How do we agents find out where military bases, installations, and airports are? Good question. There are all sorts. I'm going to ask you to go to your broker for those resources, but there are all sorts of resources online. There are plat maps. There are tax records. Google Earth is another good place to start. But check with your broker on resources you can use as an agent to help with that information. All right. Georgia, the new brochure, CB 29. I have a summary of it. Let me see if I actually have it. Yes. Let me show you what it looks like. I'm not going to read the whole thing in depth. It basically is just a reiteration of the law. But you should get it in the hands of your public people if they meet that criteria. It talks about what the law prohibits, how the 10 miles is calculated, who cannot purchase the restricted land, so forth and so on. I was looking to see if it said where you could look it up, but it doesn't. But anyway, it's just a one-page brochure. You should all use it, be able to demonstrate you did get it in the hands of your clients if they meet that criteria. All right, moving along. We're gonna hang in there. We're gonna cover buyer brokerage agreement, and then we will take a break. So, oh wait, hang on. 9:30, 10:30. Yeah. So hang in there. All right. Because I think you guys will need a break after that. All right. This is one of the biggest. Okay. So that's that. All right. Moving along to the buyer brokerage agreements. Again, these are the biggest changes regarding compensation. These same changes were changed to compensation in the brokerage agreements for clients, same verbiage in the customer acknowledgement for customers. And we're going to cover those in depth in just a minute. The other changes in the buyer brokerage agreement are the same that we've just covered in depth in the seller brokerage agreement. The protection period, those same changes. Disclaimer regarding purchase of certain property with respect to the new Georgia law, that's also in the buyer agreements. The GAR forms, that's in the buyer agreement. Statute of limitations, that's in the buyer agreements. The signatures, that's in the buyer agreements. Oh, let me show you. Well, I'm going to pull this up anyway. So let me show you. I'm going to show you this. We're going to cover the buyer brokerage agreement. We'll take a break, and then we're going to show I'm going to go over all of the exhibits that address compensation within the contract. But let me show you. This is in the seller brokerage agreement too, but let me show you this. Again, this is a universal change. Above the signature lines, as I told you, this is where it has that verbiage about if the public person signing is a legal entity. So again, that's just in every signature thing. Okay, buyer brokerage agreement, all the other changes that we discussed in the seller brokerage agreement are the same. Biggest has to do with compensation. This is the 2025 compensation paragraph A4 in the new buyer brokerage agreement. You will see there is only one now, fill in the blank where you negotiate money. The rest of it is just verbiage. So I'm going to come back to this, but I wanted you to see it in context. I'm going to go back to the slide so we can cover everything in depth. But just looking at the paragraph, only 4C has where you actually agree to the amount of compensation that a buyer's broker is entitled to for the job of helping a buyer buy a house. That's how much money they're entitled to. Now, how they get paid and who pays them, that is what the rest of this paragraph is about and what a ton of other forms are about. Remember, we talked about 3 ways a buyer's broker can get paid: directly from the buyer, directly from the seller, from the seller's broker, or a combination thereof. Regardless of whom is paying the buyer's broker, this amount here, what is established in the buyer brokerage agreement or the buyer customer acknowledgement, is the total amount, the only amount a buyer's broker can get paid for the professional services of working with the buyer side to help close on a transaction and help a property convey from seller to buyer. I'm going to come back to that in a minute, but just want to let you know. So let me go back to the slides and go over this in more depth. let me back up a little bit. And again, I'm going back to Seth's article from Georgia Realtor Magazine, fall of 2024, where he addressed this. This is going to be important because there's a lot of agent questions regarding the 2025 change. So, buyer's broker compensation cannot be open-ended and must be readily ascertainable. That's from the NAR settlement. NAR's lawyers have recently advised GAR that buyers must be obligated to pay the entire compensation of the buyer's broker to comply with the NAR settlement. What does that mean? This says the buyer must be obligated to pay that amount. Okay, we're going to come back to that. It's the view, NAR's view, that the buyer cannot give the buyer's broker a right to collect a larger amount, for example, a bonus, a larger amount of compensation from the seller or the seller's broker than what the buyer is obligated to pay the buyer's broker. The buyer, however, can continue to seek to have the seller or the seller's broker pay all or a portion of the buyer's compensation obligation to their broker. However, if no contribution is forthcoming, if there's no money coming to pay the buyer's broker from the seller's side, the buyer must, in the opinion of NAR's lawyers, be obligated to pay the buyer's broker total compensation, unless the buyer's broker waives the buyer's obligation. Also, any compensation from the seller's side must reduce the buyer's financial obligation to the buyer's broker. So, the GAR 2025 forms reflect changes. Basically, GAR had changed their contracts July of 2024. NAR looked at them and said, you got to change them. Way too much leeway. That is not within the terms of the settlement from NAR's lawyers. So, this is what the buyer's brokers and buyer customer compensation paragraph looked like in July of 2024. There was a dollar amount that the buyer was obligated to pay their broker. This says the buyer does direct their agent to ask the seller to offset to pay the buyer's broker. There was a separate amount that was negotiated that the buyer agreed their agent or their broker could ask the seller for compensation. We used to teach that this amount that the buyer says, okay, agent / broker, this is how much I'm agreeing to pay you. I want you to ask the seller to pay you. You can agree. We used to teach that the buyer, to negotiate with the buyer, that you could ask the seller to pay equal to or more than what they were obligated to pay you to account for a bonus. Here in Georgia, there are a lot of seller bonuses offered. New construction offers bonuses. Some public people offer bonuses. Hey, I really need a contract by this date. I really need a closing by this date. I want to get my kid in a new school district by this date. So there was a lot of seller bonuses offered. And the way the GAR contracts, how they came out in July, everybody used to teach, and GAR instructed us to teach that you should ask for at least equal to or potentially more than the buyer's obligation to account for a potential seller offered bonus. And then there was the option that whatever you did get from the seller side offset what the buyer owed, did not offset what the buyer owed, or special exceptions. NAR's attorney said, nope, you cannot have a different amount. The buyer, even if the buyer agrees, you cannot ask for a different amount from the seller side. Whatever in other words, your job working the buy side of a deal is worth X amount of dollars, period, end of story, regardless of who pays it. If one side is paying it, it can't be more than what the other side is willing to pay. If the seller side is willing to pay more, i.e. in a bonus, you cannot accept that bonus if the buyer themselves are not willing to pay that total amount. So we had to get rid, GAR had to get rid of this paragraph. And this paragraph, this said that GAR said no. I mean, NAR said no, no, no. Any amount of money you get, buyers, brokers, any amount of money you get from the seller side, that automatically offsets what the buyer owes you. If you have a certain amount here and you're getting that same amount from the seller side, the buyer will owe you additional $0 at closing. So we had to get rid of these check boxes because it just automatically reduced it. So that's what it used to look like July of 2024. Here's what it looks like now, moving forward. And again, this first paragraph, commission is now compensation. And just parenthetically, they changed that. There's been a lot of hoopla about that, and I'm not quite sure why. Compensation is really a more appropriate term because compensation for a job done, it doesn't matter where the money is coming from. You are still being compensated for the job of working the buy side of a deal, whether it is coming from the buyer, from the seller, from the seller's broker, or a combination. You are getting compensated for that job. So commission really referred to payment coming from the person who hired you, i.e. the buyer. So, for example, if the buyer really was paying you and the sole person paying you, it really could be commission. But because your money comes from potentially comes from a variety of other sources, it really is compensation and not necessarily commission. So that's just a down and dirty distinction between the two. And it was just easier just to change it all to say compensation. So yeah, what about bonuses? I'm getting ready to address that, so hang on. So it does say, again, per NAR, compensation to brokers is negotiable, not set by law. Next paragraph. Buyer agrees to pay the broker compensation set forth in the value of the broker's professional services section below at the closing of any contract. All right. So then how much? Well, this amount is now negotiated in this paragraph below. So, and that amount is expressed as either a percent of the sale price. You guys, for some reason, this gets confusing. This first fill in the blank, you just write out the percent in words, and then here you put it in numbers. So this would be a numeral, and this would be the words. So either a percent of the sale price, a flat fee amount, or other. The next section says possible compensation by the seller or seller's broker. The buyer directs or does not direct the broker to seek to get the seller or seller's broker to pay all or a portion of the broker's compensation above, provided it does not exceed the value of the broker's compensation above. So in dealing with most people, the buyer is going to want you to seek compensation from the seller side. And it says right here, the amount you get from the seller side cannot be more than this amount right here in paragraph C, provided it does not exceed, meaning more than the amount you just negotiated here. If the seller or seller's broker agrees to pay all or a portion of the broker's compensation, it shall reduce the compensation the buyer shall pay dollar for dollar. So whatever amount is negotiated here, if you get that same amount from the seller side, you take this amount, you subtract what you're getting from the seller side, whatever that equals is what the buyer owes at closing. So if the amount you can get from the seller side is less than what the buyer agrees your services are worth, then you're going to get, this is the total amount you can get. You'll get some from the seller side, and the buyer would be obligated to pay the difference. And it goes on to say that. Disclosure regarding broker's compensation. The buyer shall be obligated to pay all of the broker's compensation not paid by the seller or the seller's broker. Therefore, buyer, before making an offer to buy, or before you accept a counteroffer in a contract to purchase, the buyer should confirm, number one, buyer, find out, make sure of, confirm any contribution of the seller or the seller's broker towards your broker's compensation. And two, make sure you have the ability to fulfill your compensation obligation. The buyer should not make any offer to buy or accept any counteroffer in a contract that will result in the buyer paying more of the broker's compensation than you can afford to pay. All right. Woo! What do we do here? Oh my goodness. So a couple of things. Let me look at the questions and I think I'm going to answer them. Does that mean agents can no longer accept bonuses from new construction? Not necessarily. How about if a builder offers more? If the buyers have to agree up front to pay compensation, does this mean the lenders have to take into consideration compensation, a debt, or needed reserves in case the seller doesn't pay? Yep, Donna, that is a great question. And it's good to see you, Donna. And yeah, if I'm a buyer's agent and I have them pre-qualified with a lender, I'm definitely going to make sure the lender looks in their cash reserves so that I can get paid. But hang on, you guys. Woosah, everybody relax. We're going to go through this. Shall an on-site agent be asking to see the buyer brokerage agreement to make sure you're not paying more? No. I mean, you can ask, but you buyer's agents, you don't have to share you just sign a confidential contract with your buyer. Just because the other side asks for it, you don't have to give it to them. Guess what, seller? I don't care if you're new construction or not. Whatever a seller's willing to pay, if the seller is willing to pay an amount to compensate a buyer's broker up front, then they're willing to pay that. It's up to the buyer's agent to make sure they can accept that. If a seller, regardless if it's new construction or not, typically new construction does have this up front. If you don't have an amount you're willing to offer a buyer's broker, it's up to the buyer to ask for it in the contract. You can ask for it, but you buyer's agents, you check with your brokers. I'm not, and your buyers, I'm not sending you my signed agreement with my buyer just because you asked for it. You show me your listing agreement, right? So, okay. Ooh, I need to calm down. All right. Let's go over this and how this works in practicality. I need to show you the form. Okay, that's not what you meant. Okay, write out what you mean. Let me go through the slides and I'll get back to it. I get asked that a lot. So, and we get that in contracts a lot. A listing agent asking for the buyer's agent's contract. And they can ask, but anyway, okay. Notes. The verbiage does match the terms of the NAR settlement. However, as mentioned before, brokers and agents are allowed to have policies regarding fees and the fees they set based on how they work, same as in the seller brokerage agreement. What is the value of your professional services? Again, we went through that. The amount establishes, okay, so the amount negotiated here, this establishes the buyer's financial obligation to their broker for real estate services. It can be paid again by the buyer, by the seller, by the seller's broker of or a combination. So you buyers brokers, guess what? You are getting compensated. The question is by whom? And that depends on your negotiations with the contracts. Okay, I've already covered all of that. Okay. What about a bonus? So again, as I've already covered, in the July 1st, 2024 version, there was a fill in the blank that allowed for a bonus. The buyer's broker was allowed to receive amount from the seller more than the buyer's obligation. And typically that did account for a bonus. And again, in Georgia, many new construction sellers do offer bonuses. In 2025, a buyer's broker may receive a bonus, but the buyer must obligate themselves to pay the bonus in the compensation agreement with the buyer's broker. In other words, let's go back up here. Let's say just up front, let's say there's going to be a $3,000 bonus. Then how you would fill this out, you would put the buyer, your professional services for working the buy side of a deal would be worth a certain percent of the sale price plus a $3,000 bonus. If you wrote that in and then you find a house and there's a $3,000 bonus, you're perfectly able to accept that. However, in practicality, you may be hard pressed to get a buyer to agree up front their obligation to you to pay a certain percent of the sale price plus a bonus right up front. That's You're going to be hard pressed to do that up front. But that could be that would be acceptable if that's how you fill it out. So I have but will a buyer agree to that in a first meeting? NAR believes that a bonus should be for extra service, not as an enticement. Now, let's go back to what does GAR say? Seth, on behalf of GAR, may a buyer's agreement be what? Amended when a bonus is offered. Well, Seth states, again, in this article, there is a debate on whether a compensation agreement between a buyer and the buyer's broker can be amended after the buyer sees houses with a buyer's broker. In this article, Seth Weisman stated, so long as the initial compensation agreement between a buyer and a buyer's broker was entered into prior to the broker showing the buyer houses, it can always be amended later to meet the changing needs and circumstances of the parties. Check with your brokers on this. All right. What on earth does all of this mean? I see your questions flying fast and furious. What does this mean? This means that per this article, there is an apparent discrepancy between NAR's opinion and GAR. I should say Seth, because it was in the GAR magazine, but it was his words, his opinion regarding how we can deal with bonuses here in Georgia. So basically, we know that any agreement can be changed by amendment with both parties agreeing to an amendment. So how do you do this? Again, check with your broker on this issue. Let's go back to the form. Let me go back and look at the let's go back and look at the actual agreement. So there's one amount here. You find let me pull the chat back up. You find a house. Here we go. Oops. All right, I lost the chat. Hang on. There we go. You find a house. So you fill in, basically, you're going to fill in a certain amount of the sale price. You meet with the buyer, you go everything, you get them pre-qualified with the lender, you find out what house they're looking for, you fill this in, you go look at houses. So with the NAR settlement, an NAR member MLS service won't show you any seller side offered compensation up front. FMLS is independent, and it does allow a listing broker to show you how much compensation a seller or seller's broker is willing to compensate if their broker allows it and if the seller has already agreed on a set amount up front. But regardless, we're going to talk about the forms, how you negotiate this when we come back from break. But so you find a buyer, you go show houses. So first of all, let me put everybody's mind at ease. Your buyers never have to accept a contract, never have to buy a house where they will have to pay your for your brokerage services out of pocket if they choose not to. So let me talk about that. Let's say your buyer agreed to X amount. You find a house, you show a house, the buyer wants to write an offer on it. You write an offer on it. You have no information on any compensation coming from the seller side. So the buyer writes an offer, and in their offer, they ask the seller to pay their broker the amount of money, the percent of sale price that they agreed to pay, that their obligation is here. The seller can say, yep, I accept it. The seller can make a counter offer or the seller can reject it. Let's say the seller um, uh, makes a counter offer and says, I'm only going to pay half of what you asked me for. Well, okay, let me back up. Let's say the seller says, "Yep, I will pay all of what you asked me for." Great. Buyer signs it, you go under contract, you go to closing. Your buyer's broker's compensation is coming from the seller side. Buyer will owe exactly 0 additional dollars. Now let's say same house, but the seller says, "Nope, I am not paying any of your broker's compensation. If you want this house, then you have to pay your broker's compensation." Well, guess what? A buyer can say, "Thank you very much. I'm not going to do that. I'm going to go find another house, reject the counter offer, and go find another house." Or a buyer can say, great, I tell you what, I offered X amount. I'm going to increase the sale price by the amount of compensation that I want you to pay my broker because I don't have the cash. And you will still net out the same amount. And you're going to pay my broker's compensation. Seller can say, sure, I agree to that. Now, you agents, when you're doing this, you have to make sure there's room in the appraisal value. Or, third example, the seller says the buyer writes an offer, they ask for a certain amount of compensation. Seller makes a counter offer, says, I'll pay half of that. I'm not going to pay all, I'm going to pay half. So now where we are right now, this amount here, buyer is obligated to pay half and the seller is paying half. Now check with your broker. Your broker might say, well, guess what? We'll just agree to the amount of compensation coming from the seller's side so that the buyer does not have to come out of pocket any additional money for our compensation. If that's the case, what would you do to if buyer said their financial obligation was a certain amount and you're getting half of that from the seller side and your broker says, fine, we'll accept that. We don't need any additional money from the buyer side. What would you do with the buyer brokerage agreement to reflect that? Well, don't type it because I want to see these questions. You're gonna do an amendment. You would do an amendment to your buyer brokerage agreement that says, at the closing of 123 Lucky Street, buyer's broker to accept X% of sale price as compensation coming from the seller side. Buyer owes an additional $0 at closing. So you can always do an amendment to lower that amount. So now, same thought. Now let's say we have a buyer, they find a house and they write an offer and they are asking the seller to pay their financial obligation to their broker. So whatever amount here, the buyer says, I want you, seller, to pay my broker's compensation in that amount. Seller says, great, not only will I do that, I also am offering a bonus of $3,000. So now what do you do in practical means? Well, right now, as it is, you can accept the amount of percent coming from the seller side, but you cannot accept that additional money because the buyer did not obligate themselves to pay that. So what do? You do an amendment. You're going to do an amendment to the buyer brokerage agreement that says, at the closing of new construction 123 Lucky Street, whatever it is, basically you're going to say paragraph A4C shall be amended to say value of broker's professional services is 3% of sale price plus $3,000 bonus. Buyer signs it, agrees to it. Now, you buyers, agents, and brokers, you can accept the compensation from the seller side plus that bonus because the buyer has now agreed to it by amending this paragraph. Now, here's what's going to happen, however. Some of your buyers are going to say, great, good for you. Some of your buyers are going to say, the seller's offering an additional $3,000. Well, here's the deal. You can have half of that. I want 50. You can get 1,500, but I want 1,500. I want some of that additional money the seller's offering. So you say, okay, great. You're going to do an amendment to the buyer brokerage agreement that says, regarding paragraph A4C, um, value of professional services, that amount shall now read X% of the sale price plus a $3,000 bonus, 1,500 of it to go as a buyer credit at closing, 1,500 of it to go as compensation to the broker. So again, your amendment can account for bonuses, can account for whatever a seller side has agreed to compensate your broker with your broker's permission. Now, how does that fit with what we just read from GAR and NAR? Well, Seth states, let me go back here again. Seth, GAR, per GAR says, the initial compensation agreement was negotiated before we ever saw a house. It can always be amended later to meet the changing needs and circumstances of the party. Well, what's a changing circumstance? The changing circumstance is the amount of compensation coming from the seller's side as one of the terms negotiated in the buyer's offer because the buyer wants that house. So that's how you can deal with bonuses given the new changes. So let me look at the questions and then we will take a break. All right. So let me go back up here. So yes, I still think, Donna, all of you guys, you should talk to your lenders and make sure the buyer does have cash. But again, a buyer can agree to not buy a house if they do have to come out of pocket. The problem is, what happens if they want that house? Well, you'll have to negotiate it either by raising the sale price, decreasing closing costs, something like that. Okay, Lori, I apologize if that wasn't what you meant. Okay, confused. If you sign a buyer brokerage agreement prior to finding a home and the homes found each have different commission, how do you know what's the right amount for the buyer brokerage agreement? It has to be less than total. Okay, it doesn't matter. It doesn't matter what's coming from the seller side. When you sign a buyer brokerage agreement with a buyer, your services for working with the buyer are X amount of dollars. It doesn't matter who's paying it. If you decide later that you're worth less, then you can negotiate it down. If you decide later your services are worth more, you can negotiate it up. But your amount of pay doesn't depend on who's paying you. You just negotiate that. You guys, well, okay, let me come back in a minute. So this should be an amount, whatever amount that your services are worth. I mean, there are some brokers that are charging 6%, 5%, 4%, 3%, 2%, whatever. That's a discussion between you and your broker. Or if your broker allows you to negotiate your own commission, well, why? You're a professional. What are your professional services worth? How do closing attorneys set their fees? How does your dentist set their fees? How does your landscaper set their fees? How does your doctor set their fees based on what they think they're worth? There are attorneys that charge different fees. Well, figure out how much you think you're worth, and then you negotiate it depending on a specific deal. Okay, since you never know what bonus is offered, can you include? No. So Donna, great question. You cannot include, so it has to be specific. So since you never know what a bonus is being offered, can you include in the buyer brokerage amount agreement an amount not to exceed $10,000 along with a percent? I understand how you think that. And in July of 2024, we could do that. That's what a lot of us were teaching. This would be a percent of the sale price, and this would be dollar amount not to exceed $10,000. NAR said no, and even the 2025 GAR, if you put a certain percent and an amount not to exceed $10,000, you're going to be hard pressed to get a buyer to say, I'm not going to pay you 10,000, because the buyer has to be obligated. It says it down here. Buyer is obligated to pay all this amount. You're going to be hard pressed to get a buyer to say, I'm going to pay you a certain percent of the sale price plus up to 10 grand. I'm not going to sign that. So the way you handle it is with an amendment citing a specific property. And you guys, the way I told you to word these amendments at the closing of 123 Lucky Street, you're not going to do a general amendment. Let's say you do it down. Let's say the seller is offering less than what the buyer obligated themselves to do, and your broker says, yep, you can take less. You're going to do an amendment. If you did a general amendment that says at closing, buyer, this amount shall be a lower percent. If that deal falls through and you find another house and it's more, you can't take that. So you always, when you're doing your amendment to your buyer brokerage agreement, you're always going to cite the specific property address that you're dealing with. I hope that makes sense. Okay, what if the seller is offering a lower percentage, doesn't exceed? So if the seller is offering a lower percentage than the buyer's broker's obligation, then your buyer, if you don't do an amendment, you would get, if this was X amount and the seller with bonus or without bonus is paying an amount less than that, your buyer is still obligated to pay the difference at closing unless you do an amendment. Buyer brokerages are signed prior, so negotiating changed on what the seller is going to pay. Yes, the buyer brokerage is signed before you ever go out and see a house. That's part of the NAR settlement too. You have to sign, well, you don't have to sign the buyer brokerage. You have to sign something with the buyer before showing property. Seth says you need to sign negotiating a dollar amount before you ever see property. Isn't this negotiated or changed based on what the seller is going to pay? Yes, but that's a change in circumstance. Don't have to inform the seller. Nope, none of the seller's business. The seller's agreeing to pay you X. It's negotiated in a contract, or they agree up front. What a buyer owes, it's just like a buyer having to bring whatever cash to close. That's not the seller's business. I can see buyer asking for a cut of the bonus. Yep. So you're going to have to account for that. You agents check with your brokers to see what you can and can't negotiate regarding that. Basically, the only way to get a bonus is to do an amendment. Yes, right now, that is how we are instructed to teach this. Check with your own broker. So no matter what, now we have to include the buyer brokerage agreement or amendment. You don't have to include it in a contract. It's just the same. It's still your agreement with your buyer. What the seller side is paying and our buyer side. If the buyer isn't going to pay anything, would the amount just be zero? No, you cannot put zero. That's another term of the NAR settlement. You cannot put zero. Check with your broker. The minimum amount you can pay, I suggest you would put at least what you owe your broker, but this cannot be $0. That is another term of the NAR settlement. Your services are not free. So you have to put in a dollar amount. We must have the seller amount included in our buyer brokerage agreement. Okay, so what I mean is what it says right here. Possible, so let me try to clarify that for you, Christy, and everybody else. Possible payment or compensation by the seller. The buyer, most of you guys are going to put directs the broker to seek compensation from the seller's broker to pay all or a portion of this amount, broker's compensation above, provided it does not exceed the value of the broker's compensation above. So you cannot ask the seller for more than what the buyer is obligated to pay here. The amount that you and the buyer negotiate that your services are worth working with this buyer to help them buy a house property. So that's why I said that. So if the amount you're getting from the seller is different than this amount, you're most likely going to have to do an amendment to your buyer brokerage agreement and get your buyer to agree that your professional services for the buy side of the deal are different. So I hope that clarifies, Christy, why I said that, because it's written right there. Can you initially state none? No. Can you initially state none of your compensation is being given? That would be by the buyer. Nope, cannot be zero. Term of the NAR settlement. You realtors, you need to go back. We've taught a class on the NAR settlement and where you get your forms. I've got handouts for that too. So pre-showing form, good. I'm going to get to those when we get back from break. Concern breaking the law by overpaying what was agreed to, but you're saying it's really on the buyer's agent to make sure it's okay. Got it. No. Okay. So first of all, the NAR settlement, it's not law. It's not a law. It's not a civil law. It's not a criminal law. It's not any kind of law at all. This is an agreement between NAR and several brokers against the class. That's all it is. The court had to approve it. This is not law. This is not law. So you are that's a misconception among a lot of agents and brokers, frankly. You do not worry about overpaying. You're so nice, Lori. You do not worry about overpaying a buyer's broker. That is up to the buyer's broker and the buyer to negotiate their agreement to match what a seller is willing to pay so that their buyer does not have to come out of pocket. If the buyer doesn't agree to it or they can't negotiate that, then guess what? The seller gets to keep that money. How about a special stip in the buyer's broker stating, nope, that is against the terms. If you are a realtor, that is against the terms of the NAR settlement. That would go back to what the NAR attorneys negated here. You can't special stip this back in because GAR took it out. So check with your brokers, you guys, but I believe the best way to do it is to amend it. And the reason I say that is also based on what Seth said, that it can always be amended later to meet changing needs and changing circumstances. If you do a special stip, that doesn't indicate anything has changed. Therefore, do not do it as a special stipulation, but do it as an amendment. All right. Woo! I told y'all we're going to need a break. Let's take a break. It is approximately 11:28. Let's come back at 11:45. We will knock out the compensation agreements and all of the rest. Take a break. When you amend it, the buyer is going to have some say in that additional money. Come back. When you come back, again, your name, license number, email, and phone number, and I will see you guys in 15 minutes. See you soon. All right, everybody, welcome back from break. So we have covered compensation, seller's compensation and buyer's broker's compensation, which was really got addressed the most in the changes that the Georgia Association of Realtors made to their contract package for 2025. So now that we've discussed the buyer and the buyer's broker negotiating and setting the tone for how much the buyer's broker can get compensated. Now, let's go through the forms where a buyer asks the seller to pay their financial obligation to their broker for getting paid for the professional services for the buy side of a deal. And let's face it, sellers, you wouldn't sell anything if there wasn't a buyer. So let's dive in and we will finish up the rest of the class. We're going to cover that, some of the rest of the new forms, and we'll be done. So I'm going to share my screen, and we are going to go back to, oops, the PowerPoint. All right. So moving along, if you guys see me looking, I just want to make sure I've got another computer up so I can make sure that you guys are seeing, I can see what you're seeing. All right. Now, changes to the GAR forms that address compensation. We've got 3 forms that address, again, buyers, brokers, compensation, as well as a special stipulation. So we talked about at the beginning, a seller's compensation, a seller's broker gets paid directly from the seller, and that is negotiated and agreed to on the seller brokerage form. But because of due to the many ways a buyer's broker can get compensated, we've got a lot of forms that go along to help a buyer ask the seller side to pay their compensation to their broker. So one of them is the F-258, the pre-showing compensation agreement. Another one is the F-259, the buyer's broker's compensation agreement, as well as the instructions to closing attorney. So you can also, buyers may also ask the seller for to compensate their broker via a special stipulation. Now, just a quick word about the instructions to closing attorney. GAR has come up with all of these new forms basically in July. Actually, the pre-showing compensation agreement used to be called the pre-showing co-op agreement. That form's been in existence for years. It was very rarely used. It's been used a lot lately. But although it is not necessarily required, if compensation has been agreed to and signed by the parties paying in another form, it is a good practice to include the instructions to closing attorney to the parties, send as a good summary, and send it to the parties, the closing attorney, the co-op agent, and your own broker as just a summary of what has been negotiated and agreed to regarding compensation to make sure everyone is on the same page. Now, check with your broker, but I think it's just a good, again, summary to make sure nothing got missed. So, but let's go through these forms. Well, before we go through these forms, here's another question you need to ask yourself. Should the buyer request their brokers? Okay, so you don't know. If you don't know if the seller's broker, the listing broker, is sharing part of their money in a co-op deal, you have no idea how much or if or from whom seller side compensation to the buyer's broker is coming. Who should the buyer ask it from? Should they ask it directly from the seller or from the seller's broker? So if any seller side compensation for buyer's broker is unknown, buyers should contractually ask for compensation to the buyer's broker be paid directly by the seller. Why, Dana? Why are you saying that? Well, the reason is it avoids you as an agent from violating license law and the Realtor Code of Ethics. The license law you could potentially violate is the unfair trade practice, Georgia Code. There's the Georgia Code, and Realtor Code of Ethics, Article 16, Standard of Practice 1616. Basically, those say that you are not allowed to negotiate an amount of compensation that a public person has agreed to pay their broker. So if you inadvertently, if your buyer asks for compensation to be shared by the seller's broker and they haven't already agreed to that, that potentially could be perceived as you impacting or cutting into their compensation, and that would be a potential violation of license law and the code of ethics. Therefore, to stay away from that, just ask for it from the seller directly. If the seller has already agreed to pay their broker a big pile of money and their broker is sharing it, then the duty is on the listing agent, on the seller, to make a counter offer regarding how or where the buyer's broker is getting compensated. But it should initially be asked from the seller directly. So in the pre-showing compensation agreement, the only minor change is they changed the date line. It used to have date and the property address, and they've just changed the formatting of that to match all of the other forms. I'm not, well, let me see if I do have this. Additionally, they've changed the signature line. So let me so basically, this is the pre-showing compensation agreement, and this is a situation where you agents, in advance before you ever show a house, hence pre-showing, before you ever show a house, you know that there is compensation coming from the seller side, and you know exactly how much that is. So typically, this is going to be coming from a listing agent, from a listing broker. The seller has agreed to pay their broker a big pile of money. Their broker is sharing it with you. That's typically going to be when you're using the pre-showing compensation agreement, in which case it's just signed by the two agents. There is a signature line for a seller if, and it says it only needs to be signed by the seller if the seller is paying the buyer's broker directly. Now let's think about this. Many sellers aren't going to decide how much they're going to pay a buyer's broker until when? Until they see the buyer's offer. So that is typically going to be addressed in another form or using a special stipulation. So you're probably not going to use this pre-showing compensation agreement if the seller is compensating the buyer's broker directly. It's usually just for a co-op situation, and if it's not coming from the seller directly, the seller doesn't sign. So if you don't know, that's what I just went over. If you don't know, then what are you going to do? Well, yes, the F-258 is for the traditional co-op split. So let me show you the actual form. The F-258 is very similar to the instructions to closing attorney. It definitely is for a traditional co-op, when the co-op agent is saying, yes, I've already been paid, I will be paid money and I am going to share that with you. So that is a traditional co-op, and you would use the pre-showing compensation and only the broker sign it. So pre-showing, this is the amount being paid to the buyer's broker. Who is paying it? Typically, it's going to be this middle one, seller's broker, out of the compensation that the seller is paying them. That is the traditional co-op. And then it is just signed by the two agents slash brokers. So it has this additional seller signature. But again, usually a seller isn't going to agree to an amount before ever seeing the offer. So yes, this is the form to use in a traditional co-op, when when the seller's broker shares with you how much they're going to share. So now let's look at the next form. So if you're going to ask the money's going to come directly from the seller. We don't know. Buyer's agents, sign a buyer brokerage agreement or with a buyer, you're looking at houses, they want to write an offer. You have no idea how much or who is paying for the buyer's broker's compensation. The buyer says, hey, I want you to ask the seller to pay all of the amount of money I'm going to owe you at closing for the buyer side of the deal. So one of the ways you can do that is through this exhibit, the buyer's broker's compensation exhibit. It's F-259. It used to be called brokers, but they did away with the seller side, which we knew they were going to do. If you have already agreed to compensation on another agreement, i.e. the pre-showing compensation agreement, you don't need to use this. If buyer's writing an offer on a house, buyer says, ask the seller to pay you what your services are worth. You are either going to use this exhibit or you're going to use a special stipulation. This exhibit, you fill in the name, the property address. This says, this is the amount either shared by the seller's broker. So if it is a traditional co-op, sellers paid their agent a big pile of money, their agent is sharing it with you, then you are going to fill out this first portion. This is the amount shared by the seller's broker with the buyer's broker and how much. This is the traditional co-op. But let's say we don't know that. If we knew that, we're probably going to use the pre-showing compensation agreement. So let's say we don't know this. Again, I directed you in this class. It's safer to avoid violating license law to have the buyer ask the seller directly. So the most the most frequent way this form is going to be used is you're going to fill out 1B. The buyer is asking for compensation to their broker be paid by the seller directly. The compensation to be paid by the seller to the buyer's broker is, and you fill out that amount expressed as a percent, flat fee, or other. This should match what you filled out here. This buyer's broker paragraph 4C should match what you're asking, what the buyer is asking the seller to pay directly, so that the buyer incurs 0 additional out-of-pocket dollars. And then there's the agreement. None of that has changed. So I'll show you what changed in a second. And then buyer signs it and seller signs it. Again, what is it, you guys? It's an exhibit, right? So buyer and seller sign it, and there is a place for the agents to sign. Now, you buyer's agents, you definitely want to sign it because you want to confirm you're getting paid. You listing agents should sign it, but the seller, if the money's coming directly from the seller absolutely has to sign it. The buyer's going to sign it because you want to confirm that that amount is going to offset what you owe. If it is a traditional co-op, seller's agents need to sign it too. So that's the change in this form is there's just who and how much is being paid to the buyer's broker coming from the seller's side. The change from 2024, July 2024, there was a paragraph that said how much is the seller's broker getting paid and from whom. Well, thank you, GAR, for getting rid of this. Again, this form is being initiated by the buyer's agent in an offer. We have no clue what negotiations have gone on between a seller and a seller's broker. So you were either forced to leave this blank, which you're hard pressed. You've been taught for so many years never to leave blanks in a contract, or to guess, and it potentially created the need for a counter offer when there wasn't one. So GAR got rid of that, which completely makes sense. Now, let's go on to changes to instructions to closing attorney. Not a lot of changes, but it just now makes sense with what we've talked about this whole time. They've added some check boxes, and they've added some signature lines. So again, it has compensation paid by seller to seller's broker. One way a seller's broker can get paid, and that's how much. These next 2, 3, and 4 is compensation to a buyer's broker, who's paying it and how much. This first one is a co-op. This is compensation shared by the seller's broker with a buyer's broker. This next one is compensation from the seller directly to the buyer's broker. This next one is compensation directly from the buyer to their buyer's broker. So let's say in the buyer brokerage agreement, the buyer agreed your professional services for the buy side of a deal are a certain amount. Let's say the seller agreed to pay half of that and the buyer is going to pay the other half. Then this part's going to be filled out by the seller side. The seller agreed to pay their broker X amount. What about the buyer's broker? You're going to fill out 3 and 4. Compensation paid directly by the seller to the buyer's broker is half of what the buyer agreed to, and the buyer themselves are also going to pay a certain amount. So that would be an example of how this is filled out. On page 2, this is, you fill this out if there are any rebates going from the broker back to the buyer or the seller, or if there are any referral fees. That has to be filled out there. Now, what also got changed is the signature lines. So let me show you, I can show you a little bit easier on the actual form itself. And instructions to closing attorney. Basically, there is, so typically, if it's just a traditional co-op, just like normal, it's just the agents that sign it. If the seller, there's a new buyer signature line and seller signature line. GAR gives us instructions. If the buyer is paying the buyer's broker compensation, as referenced above, then the buyer has to sign. If the seller is directly paying the buyer's broker compensation, then the seller has to sign. So those are the changes to that. So not bad, not many changes. All right. Whew, I'm running out of time. All right. Special stipulation. This is the other way that a buyer can ask a seller to pay their broker. A special stipulation basically, there is GAR special stipulation 620. Buyer requests seller pay buyer's broker's compensation, again expressed as a flat percent of the sale price, flat fee, or other. Then it has this extra sentence. Nothing herein shall be interpreted as a request to alter, modify, or change the commission to be received by the seller's broker, if any, that the seller has agreed to pay their own broker in a separate written agreement. You guys do not write this special stipulation on your own. Use the GAR provided special stip to include this sentence to avoid potentially violating license law. Now, GAR has this same special stipulation with respect to VA borrowers, but VA changed their regulations in 2024, so you're really not going to use that. All right. Purchase and sale agreement. All right, so that's it for the broker compensation forms. All right. Let's talk about the changes, just a few minor changes in the purchase and sale agreement. So we're going to cover these financing exhibits and the new forms, and then we will be done. So hang in there with me. I promise we will get it all done. We're almost done, actually. All right. This is the GAR purchase and sale agreement. Let me go up to the top. 2025 printing, not a whole lot of changes, but a couple. Under this earnest money section, it used to say earnest money will be paid to the holder, and it used to say check, certified funds, ACH, blah, blah, blah. They have changed it to just say a method of payment acceptable to the holder. You agents, you need to check with the holder. If you typically have your broker as the holder of the earnest money or closing attorney, you need to check with them what forms, what are their policies regarding earnest money? Do they take personal checks? Do they require certified funds? Is there a certain amount that they require certified funds? Is there a certain amount they require for wire? Get their wire instructions up front so you can hand them to your buyer. So again, that is a change for 2025. Uh, Additionally, GAR has added this in. This is, I believe this has always been Georgia landlord tenant law, but GAR added this in that if there is a lease, buyer agrees to assume seller's responsibilities in any lease specified in this agreement and the closing of the sale of the property. The lease itself does not terminate. Just because a landlord sells a property to a buyer, the lease remains intact. So you buyer's agents, you need to make sure your buyers understand that. They've added a new section on just additional verbiage on prorations. We know that all the property taxes at closing is the closing attorney's best guess based on the last property tax bill, but there could be some assessments out there, some appeals, so forth and so on. So they've just added this verbiage that says the party who paid less than their pro rata share of taxes to the other party at closing or collected more than their share from the other party shall, upon the issuance of the actual tax bill or any special appeal being resolved, promptly pay the other party the amount necessary to correctly prorate. Now, that's just verbiage added in there for 2025. Okay, this is a big change. This is probably the biggest change to the purchase and sale agreement. The right to unilaterally extend a closing date for 8 days. You guys, that's not Georgia law. That is just a Georgia Association of Realtors contract provision. Now, what got changed? So that has always been the case, but this right for one party to send unilateral notice to the other party to extend the closing date by 8 days, it's not willy-nilly. It has to be based on one of these reasons. Those haven't changed, but that right did go through 11:59 p.m. day of closing. However, GAR is trying to be able to afford us agents a life so we don't have to stay up till 11:59 p.m. To receive or send a notice. So for 2025, this is a big deal, you guys. GAR has added in a time frame. So if one of the parties is going to send unilateral notice to extend the closing date, the last point they can do it is day of close. They can do it beforehand, but it's day of closing, but they must send the notice before 8 p.m. day of closing. Now, all of these other provisions are intact, but they've added in that time frame. Big, big change. So that's really good for us. This basically says that the holder of the earnest money, if the earnest money is not honored by the bank and the holder incurs bank fees, like a bounce check charge, a wire fee, something like that, the holder is allowed to charge the buyer an additional fee. They're allowed to pass on that bank fee to the buyer. So again, there are financial consequences for the buyer if the earnest money is dishonored or not timely paid. All right. Another minor change where it has buyer, it used to say right to inspect neighborhood. Now they change it to buyer's responsibility to inspect the neighborhood. Designated agency disclosure, they just added a little bit of clarifying language where it just says if the broker in this transaction is acting in a designated agency capacity where one or more licensees of the broker are exclusively representing and one or more are exclusively representing the seller. They've added in one or more to account for more and more teams. We have a lot of teams operating in Georgia, and this would be, for example, a team leader and a buyer's agent. That team, that's why it says one or more. So they've just added that to account for teams. Not a big deal. And this change was made in July, but a lot of uh, agents don't realize they've added this back in. This is under the defaults paragraph. If a buyer defaults on a contract, the seller's remedies are the same. They basically get the earnest money as liquidated damages. If a seller defaults, however, the buyer, they still can seek specific performance. They can terminate the agreement and get their earnest money back. You guys, if a buyer is going to seek specific performance, that means they go to court and make a judge rule on the contract and make the seller go through on a contract. If that's what they're going to do, the earnest money stays in the deal until the court case is heard and decided upon by a judge. That could be 2 months to depending on the county of the court when that case is going to be heard. It does tie up the seller's house, but it also ties up the buyer. Or a buyer can terminate this agreement, get the earnest money back. What got added in July is the and buyer may pursue any other remedy available at law, meaning a buyer can sue a seller for additional financial costs that a buyer has incurred if the seller defaulted on a purchase and sale agreement. So that's a pretty big deal that GAR added that back in July. And what was happening is we were having a lot of sellers just terminating contracts at the last minute in favor of a contract with a higher price. So that's why GAR added that back in. Other provisions, this is a big deal, not a big deal, just important. They added in delays caused by emergencies that, based on the weather emergencies that we had last year, GAR added in that if the governor of Georgia declares a state of emergency in the county in which the property is located, all time deadlines, including closing date, are automatically extended for the number of days that that emergency exists in the county. Now, the buyers and sellers can go ahead and agree to not extend them, but they are automatically extended. And it also states that that it's automatic, because you don't have to sign to agree to that, because especially like in the hurricanes or the wildfires, things, we don't have wildfires here. Well, I don't know. But anyway, the parties, their electricity and their internet may be out, so they might not be able to sign. So that's automatic. Digital signatures, that used to say electronic, so not a big deal. GAR forms, that's a universal change. I addressed at the beginning. This is just a legalese thing. Basically, we had some buyers that were recording before they ever closed. They were recording with the courts that they basically had an interest in the property. And if the deal fell through, buyers were never releasing that from the court. So that potentially tied up the seller from being free to sell the property to another buyer. And so GAR put that in there, that a buyer is not allowed to basically put a legal, it's not a lien, but it's recording a lis pendens against an interest of the property unless they truly can demonstrate an interest. This section here, property to be delivered in clean, broom swept condition, free of trash, garbage, debris. We've had so many agents last year asking me for, where is that? Where is that? They were writing a special stipulation. I'm like, it's already in the contract. Well, it was in the damages paragraph. And because so many agents couldn't find it, they just separated that out into its own paragraph. So the verbiage is the same. It's just teased out into its own paragraph. Under the rules for interpreting this agreement, basically, they've added verbiage here that basically says it has to do again with compensation. That if broker's compensation is negotiated between a buyer and a seller, either on the exhibit F-259 or in a special stipulation, that buyer and seller cannot just do an amendment to change the amount of pay that a buyer's broker or seller's broker for that matter, but a buyer's broker is getting. They can't do an amendment to change a special stipulation without the broker's compensation being affected signing on that. So it just says that the anything having to do with compensation is only enforceable between the I'm sorry, that's already been there. Changes to the total amount of compensation due to any broker from the amount that has previously been agreed to in writing is only binding if the broker impacted by such a change consents to the same in writing. So again, with the F-259 or with a special stipulation, buyer and seller can't negotiate that away to make a deal work without your written approval. Statute of limitations, again, changed to 1 year. And that is about it. Then again, uh, the signature admonition for entities. So that's it for the purchase and sale agreement. So again, the biggest change is really the 8-day unilateral. Okay, let's move on to the financing contingency exhibits. Universal changes among the financing exhibits. They removed the term mortgage with respect to a lender. They've added new language regarding if the property is a condominium. They've talked about loan denial, and let me just show you the form. I think it's easier just to show you guys the actual forms. All right. So this is the conventional loan contingency exhibit. Again, they removed mortgage. It used to say use a particular mortgage lender. They removed that term. They've added this whole new paragraph that basically says if the property is a condominium, now that's not style, you guys. That has nothing to do with one level, two levels, attached, unattached. That has to do with ownership, or is subject to a master insurance policy. That basically the lender has to make sure that that property that fits with their underwriting guidelines. And if not, then the buyer shall have the right to terminate this agreement without penalty, receive full refund of all earnest money, as long as the buyer sends notice to the seller that it does not meet the lender's underwriting approval for the condo project or based on this master insurance policy. And they have to prove it to the seller with the letter from the lender. And buyer's right to do that goes through closing. That's been added to all the financing contingency exhibits. Now, let's say we're past the financing contingency, buyer didn't terminate, they're going to go through with it. Well, the seller now has the right to request evidence of the buyer's ability to close. For 2025, GAR added this last sentence that says it is intended that the evidence the buyer produces shall be liberally interpreted where possible in favor of finding that the buyer has the ability to close on the purchase of the property. And then this is one sentence has been added. This is under the appraisal contingency in the conventional loan exhibit that basically if the property appraises for less than contract sale price, the buyer has got to give the seller the opportunity to sell it to them for the appraised price. They have to send a notice to the seller, not a notice, they have to send the amendment to the sale price, asking the seller to sell it to them for less, and a copy of the appraisal. And then the time frames have not been changed built into here. But if the seller says, yes, I agree to the lower sale price, the buyer then must go through with the contract and the appraisal contingency terminates. So they've just added that a little bit for clarity. Now, in the FHA and the VA loan contingency exhibits, majority of that is those universal changes are the same. They got rid of mortgage. They added in the special approval for a condo or master insurance policy. They've added in the liberal interpretation of a buyer's ability to close. But this is a big difference for those of you, my agents who, you guys, y'all have been working for several years. There was a big difference between the FHA and VA insured loan and the conventional loan if the appraisal came in low. Now, we know on these insured loans, it's not called appraisal, it's called the amendatory clause. Basically, has to appraise in FHA for this dollar amount, VA for reasonable value as established by the VA. In the past, if that appraisal amount, I'm using air quotes if you can't see me, came in less than the contract sale price, these buyers had termination rights through closing. They could just terminate. Now, in the GAR contract, if a FHA or VA buyer appraisal comes in low, the buyer has got to give the seller the opportunity to sell it to them for the appraised value. Now, it still does not negate the amendatory clause. If the seller does not agree, the buyer still has termination rights with refund of earnest money through day of closing per the amendatory clause. But the addition is they have to give the seller the opportunity to agree to sell it to them for the lower price. And if the seller agrees, the buyer has to go through with it. So brand new paragraph in the FHA and the VA exhibits. Additionally, in the FHA and VA exhibits, there has always been this provision that a lender may require the property to be connected to public sewer. You negotiate how much that's going to be. Well, if the lender actually does require it and the amount to connect is more than that, what happens? Well, GAR has now added this paragraph that the amount in excess to what was previously negotiated, buyer and seller determine who's going to pay it. If they don't pay it, contract terminates, buyer gets refund of earnest money. So those are the changes for the FHA and the VA loan exhibit. Temporary occupancy agreement for buyer prior to closing. This is very rarely used, definitely not a good idea, but sometimes required. What got changed is the security deposit. It used to be paid to a holder, and now the security deposit a buyer pays to a seller for moving into the house prior to closing is paid directly to the seller. And there's also the reminder of Georgia landlord tenant law, or Georgia landlord law, that if the owner owns more than 10 properties, then those laws kick in, which basically says the owner must put it in a trust account and follow all the trust account laws. Seller's property disclosure statement, only 2 additional questions. One is under systems and components. GAR added the question, is there any spray polyurethane foam insulation in the property? And under soil and boundaries, GAR added, are there any underground pipes crossing the property that do not serve the property, i.e. they cross your property probably to service a neighbor? Okay, here we go. Another new form, brand new form. Seller's notice to unrepresented buyer, seller's broker's notice. So a seller's broker means a seller has signed a seller brokerage agreement with the seller. So the broker is working with the seller as a client. And this is a notice. So it only needs one signature sent to an unrepresented buyer, a public buyer, not yes, right of ways for gas and pipelines too. Yes, Donna, great thing. That other form, if I'm a seller and there are rights of ways, that I would definitely use that as well. Have the seller check that as well. Good point. So you put in the name of the buyer, and this is the name of the brokerage or licensee working with the seller and the property address. This informs the buyer, who has no agent, that you can only perform ministerial acts because they are unrepresented, and that you are working as an agent for the seller. Buyer is responsible for protecting buyer's own interest. And you would send them, you would also be able to allow them the opportunity to review the ABCs of agency. Um, when are you going to use this? Well, an agent having both sides of a transaction but not dual agency, you could use that if you're working with the buyer as a customer. There are GAR does have a customer agreement that you should get the buyer to sign because it explains what that is. But if they won't sign that, this would be a good use of this form. Are you going to use it on sign calls? No, because you are working for the seller. So I take that back. If there is a buyer not represented, but check with your broker of when you're going to use this form. Brand new form. Another new form, showing agreement. Now, this form, I'm not sure when you're going to use this form. If you are a listing agent showing your listing to an unrepresented buyer, you do not use this form because you're being paid by the seller. This is a showing agreement. Showing agreement. Broker agrees to show buyer the following property without the buyer, without owing any compensation. Broker is not being paid compensation by the seller either. So that's why you listing agent showing a buyer your property, you're not going to sign this because you are getting paid by the seller. This is just, you are opening doors for free. So check with your broker. I am really, really not sure when you were going to use this, but GAR has created this. There are some other companies, big national companies out there that have something similar, but check with your broker. This is basically just opening a door, and you list the properties being shown. A couple new forms, and then we're done. I know I'm over. Give me 2 seconds, and I will finish up. This is a form really good to use in an open house visitor sign-in sheet that basically says, okay, anybody who comes into this house, this is for a resale house, don't get hurt. Don't trip. Don't fall down the stairs. There are things that can cause you injury. You sign it. The buyer puts their name and signs it, and it basically says, be careful, hold on to handrails, only go in well-lit areas, keep children with you, blah, 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 be careful. There is the same form, you new construction agents, this is the same form when viewing a house under construction. There are things in new construction sites that are dangerous and you can get hurt. You acknowledge that and you agree to look out for your safety, name, and signature. Then there are some changes to the lease. I'm not going to go through that right now. You leasing agents, just make sure to look at that. I will just briefly address 3 new forms and then we are done. So hang in there. These do have to do with leases. This has to do with making sure that landlords and agents and brokers comply with the Persons with Disabilities Act. This is you agents working with tenants. This is an application to a landlord to modify a property to accommodate for a certain modification for persons with disabilities. Here's their request. Brand new form for that. Then landlords, here is a form for you to send back saying this is your policy to allow for reasonable accommodations and modifications for persons with disability. And a lot of this is spelled out in compliance with various laws. And then the third related form to this is the tenant asks, the landlord responds back with their policy, and then the landlord responds back with their response to the request the tenant made, approved or disapproved, and why, and they sign it. And though that is it for the new forms. Again, my slides cover everything that I have discussed verbally. Happy New Year, everybody. We did make it. I only went 4 minutes over. I appreciate your time. I will stay on to answer questions. If you do have to leave, like many of you guys are doing, name, license number, email address, one last time in the chat. Remember to confirm all of your contract questions with your broker. We do have additional CE classes. Again, starting in February, March, April, we're going to have in-depth classes on the purchase and sale, on the brokerage agreements, how to fill all that stuff out, what some of the concepts are. Again, that's where handouts are available to you. My YouTube channel goes into great depth into all of these concepts, as well as a lot about license law, code of ethics, contracts, so forth and so on. And I pray that God helps you bless others through your real estate license, as well as all blessings available to you, and that you do feel God's presence. Have a joyous and prosperous year helping others with their real estate needs. I will stay on and answer questions because everybody is typing a lot in the chat. Thank you guys so much. Feel free to unmute yourself and ask a question, and I'll be happy to answer it. Thank you. Any questions, anybody? This is where everybody stays on to hear everybody else's questions. Okay, regarding the new option C1 exclusive listing agreement, are we able to market in Georgia MLS and FMLS that the seller is open to offer that include the seller paying broker compensation? How do you make buyers agents aware? Okay, great question, Todd. So Todd's question has to do with tying in with the seller's compensation agreement and I'm sorry, exclusive listing agreement and the compensation. Let me find that and go through that. So the answer is yes, you can do that. And okay, let me go back here and share my screen. And let me know if this is what you are asking, Todd. Okay. Here in the seller, I'm in the seller brokerage agreement, and we're filling out this amount. And so what are you asking, Todd? Are you asking if the seller is open to offers that include buyer? Okay. So let's say the seller wrote this one. Not initially offering. I'm not okay, my listing agent. I don't want you to say how much I'm offering, but I am willing to offer compensation to a buyer's broker. Just a point of practice too. You listing agents, y'all need to, if you haven't been doing them, many of y'all are doing them, but if you have not been doing them, you need to get back to doing seller net sheets. And in your seller net sheet, I would account for all sorts of terms that a buyer's going to ask for. A buyer's going to, all sorts of concessions a buyer's going to ask for. A buyer's going to ask for closing cost compensation. Well, a buyer's also going to ask now for their broker's compensation. They're going to ask for contingencies. They're going to ask for closing dates. They might ask for repair concessions, appliance concessions, all kinds of concessions. You listing agents, don't wig out. Don't make it so funky for your sellers. It's just another concession that a seller needs to take into account when negotiating their contract. So when you're doing a net sheet, I would account for, just like on a net sheet, you're going to account for various sale prices. You're going to account for a seller making a various contribution to a buyer's closing costs. It's just going to be another line item concession that a seller's going to negotiate. So when you're doing a net sheet, you're going to account for more money than what they're paying you in compensation. It's just a concession. So let's say the seller says, okay, I don't want you to say how much, but I do want you to market that there is money coming from the seller side to a buyer's agent. Well, here in the marketing section, I went past it. It does say that if you're listing it in whatever MLS services that you can list it. So how do you market that? You listing agents, how do you market that? Well, you could do it a couple of ways. You could just say, um, check with your broker. There's a variety of ways that your brokers might have you do it, but some ideas would be um buyer's broker compensation, or um seller is willing to compensate buyer's broker with an offer, or buyer broker friendly, or um if there is the exact amount in FMLS, if your broker allows it, you are allowed to market how much a seller is offering. Um, in Georgia MLS or any NAR owned MLS, you cannot. That's part of the settlement. But you can in email to email, not in showing time. But let's say that you get an offer from a buyer. Let's say a buyer's agent calls you and says, "Hey, is the property available?" The buyer's agent, you listing agents, you can say, "Yeah, it's available." Not only is it available, there's an X% co-op fee. And you're the buyer, here's the pre-showing compensation agreement. Or yeah, and the seller is very willing to compensate the buyer's broker. Just make sure to include it in the offer. So if the seller said, yes, you can you can say that we will look at it in an offer, not how much, then you listing agent, you say, yes, the seller is willing to compensate a buyer's broker, and the terms of that will depend upon the buyer's offer and all of the terms of the offer. So you could do that in MLS, because even in the NAR settlement, the NAR settlement says a listing broker can market that there are seller concessions. It just can't specifically state that a seller is willing to compensate a buyer's broker. You can't bring it down to buyer's broker compensation, but you can say seller concessions. Another thing that I've seen is there's a lot of billboards and banners out in front of new construction where it says seller is offering X amount of dollars for a buyer to use any way they choose. And that, so you buyer's agents, you can use it off the sale price, you could use it towards closing costs, you could use it towards compensation, you could use it towards buying down points, whatever. So some of this on the buy side is going to depend on the buyer situation. Do they have a lot of cash and they want a lower sale price where their mortgage payment is less over the years? Or do they have good credit, not a lot of cash, and okay, I can handle a little bit more in a monthly payment spread out over 30 years, but I don't have the cash. So you listing agents, you can offer just seller concessions with offer. You could do it that way. You just can't specify it's towards buyer's brokers compensation. So I hope that answered your question. Any other questions? Nope. All right, everybody. Okay. Do I offer classes or YouTube videos covering leases or lease related forms? Great question. I do not at this point have any, but I think I am going to. I did in years past. There were a lot of lease purchases and a lot more leases. I think we might end up um getting into maybe more of that market as we go further. So I will I will commit to doing that this year, is putting some classes and YouTube videos over more leases. Okay. For those of you, you do not have to stay on, but for those of you who do want to stay on, a couple of the lease changes. Let me go over. There's not a whole lot. So let me share my screen. There's just a few changes, so let me cover those. This is the lease, and these are in the handouts with the underlines. Again, not a ton of changes. Rent, basically the biggest changes are if a tenant is in default for paying their rent and the landlord is taking action based on Georgia law, to notify the tenant and starting eviction proceedings. Landlords have to post notice to vacate on the door. As required under Georgia law, each time a landlord has delivered and posted a 3-day notice to vacate to pay, or pay to tenant due to tenant's default for unpaid charges, the amount specified in earlier in the lease. This shall be in addition to rent with along with the other. So basically what this notice is, you have to post it on the door. So they've added that just as a clarification or just to remind people, landlords of the law. And additionally, if it is a holdover tenant, they've added in the event tenant holds over beyond the term of the lease, the demand for possession notice shall be posted in a seal. Okay, so this one is just you have to give them that right to do that. This is where the envelope on the door shall be posted in a sealed envelope conspicuously on the door of the premises, in addition to any other notice sent to the tenant hereunder, which is by US mail. So you have to also post it on the door. And uh, under default, they removed language about a tenant filing for bankruptcy. And again, if a tenant is in default, they've added the information that the landlord must also post the tenant being in default and the right to cure in a sealed envelope conspicuously on the door of the premises as a notice to vacate or pay within 3 days, as well as other means of how they notify the tenant. And then this is a big part here too. This says, so we know per Georgia landlord tenant law that the landlord is responsible for providing the tenant with a safe property, a safe and habitable property. But this says if the landlord doesn't know that there's been damage or dangerous condition, the landlord can't be held responsible. So GAR has added to the lease, tenant shall immediately notify landlord of any dangerous condition or need for maintenance existing in the premises or on the property. Landlord shall have no liability for damages or injuries resulting from the tenant's failure to immediately notify the landlord of any dangerous condition on or in the premises. And I believe just the indemnification that again, if uh, there is a dangerous condition in or on the property and nobody notifies the landlord can't be held responsible for that. So that's just a reiteration of that. And that's it. So just a few changes to the lease, not a lot. I hope that helped. You're welcome. All right, everybody. Happy, healthy, prosperous, blessed new year. It's going to be a really, really good year for real estate. I thank you so much for your time. I hope this helped a little bit. I think when you go over the forms and actually start using them in practice, a lot of this will make more sense. Please, I always defer you to your own broker, but I will be more than happy to answer questions from an instructor if you're not one of my agents. If you're one of my agents, obviously I'll answer as your broker. Thank you guys so much, and I appreciate your time. Thank you. All right, I'm going to stop recording. All right. Thanks, everybody. Bye.